Hi, everyone. Welcome to Criminal Convictions and Immigration Status, a conversation with an immigration attorney. I'm going to first start by saying this webinar is for informational purposes only, hopefully a lot of information, but it's not intended as legal advice to anyone watching. Legal advice can only be given in the context of an attorney-client relationship established with an attorney. So if you have any particular issues, be sure to contact an attorney to discuss those specifically. I'm Jean Humbrecht, criminal defense attorney in Manassas, Virginia. I'm here today with Amy Long, who is an immigration attorney in Massachusetts, who used to have a practice here in Virginia. Thanks for being here today with me, Amy.
Sure, I'm glad to be here.
Can you tell everyone a little bit about you and what it is that you do?
Okay, sure. So my name is Amy Long. I'm an immigration lawyer, as you had mentioned, and I'm licensed to practice law in Virginia, and I was there in Virginia. I had an office there for 10 years. I'm now located in Massachusetts, but I represent clients from all over. The majority of my clients actually still are in Virginia, so that's a good thing. And my website is immigrationfallriver.com. Please come and visit me. I've got lots of information, how the current situation that we're in is impacting the immigration world. I have videos, things like that. Please visit me, immigrationfallriver.com.
Okay, so Amy, can you tell us a little specifically about the types of cases that you handle for those that might not be familiar with what an immigration attorney does?
Sure. I handle family-based immigration. I handle employment-based immigration, and I handle naturalizations. So that's the majority of what I do. A petitioner will approach me, or sometimes it's the beneficiary who approaches me and says, look, I want a petition for a loved one, or I need to get my immigration status straightened out. And then I get all the parties involved together, and they typically hire me. We enter into what I call a representation agreement that explains the scope of representation and how the money is handled, some of the logistics that they need to know about, and then we get started from there.
So in the course of all of that work, do you ever run into issues that involve criminal convictions?
Yes, absolutely. And yeah, that's a big deal. One of the first questions I'll ask someone during a consultation is, there may be some uncomfortable questions here, but I have to ask you is, do you have any arrests or convictions anywhere in the world? And that's our starting point. So I need to know that. But
so why is that something that you need to know for purposes of what you do?
Well, there's a possibility that a criminal conviction could make them inadmissible. That is to say that they would be ineligible to get a green card. However, all isn't lost. Even if they're inadmissible, there could be a waiver available for them. It's additional paperwork, it's additional fees. Or that criminal conviction, if they already have a green card and they're applying to become a U.S. citizen, could subject them to a ground of deportation, and we need to know that as well.
Okay, so can you tell everybody a little bit about the types of charges that could make someone inadmissible or deportable?
Sure. So the immigration world really is divided into, for criminal purposes, is divided into crimes involving moral turpitude and aggravated felonies. So the Immigration and Nationality Act has enumerated what is an aggravated felony. It's actually listed in there what is considered an aggravated felony. And when you compare it to the state or federal charge, it could be a misdemeanor. It could be because in the immigration world, they have their own definition of what is an aggravated felony. And it often involves a jail sentence of at least a year. In addition to the nature of the crime, and that includes suspended sentences. So you can have a client who says, well, I never saw a day in jail. Well, you still could have gotten a year. So they potentially have an aggravated felony. And then there's crimes involving moral turpitude. Those are not enumerated anywhere. It's up to the lawyer to read the language of the statute to determine whether or not it's a crime involving moral turpitude. Does it involve a mental state that is vile, depraved, base? Does it have words like knowingly, willfully? So there are some crimes which after a while the practitioner already knows it's going to be considered a crime involving moral turpitude. The most prominent one that comes to my mind is a theft offense.
Okay, so is there, when you're talking about crimes involving moral turpitude, is there a bright line, or is it something that could be open to interpretation?
Right, it's open to interpretation. There's no bright line when it comes to crimes involving moral turpitude, and then it gets more and more complicated as you go on. Is the statute divisible or not? Is there parts of it that have an intent requirement, and parts of it that don't? But that's a more complex conversation.
Okay, so do you come into the process after somebody already has gotten a criminal charge, or do you work with people to try to get status, and then in the course of that they might find themselves in trouble? Where exactly do you come in the process?
Well, when they come to me, we see what happens, and I've seen the whole gamut. I've seen people who have come to me and they already had a criminal charge, and it's sort of too late to talk to the criminal defense attorney about how to plead the case or what have you, um, or to see if you can lower the charge, lessen the charge. And then I've had clients who are already active clients of mine, and then they commit a criminal offense. And in that situation, then I can talk to the criminal defense attorney. Together we can discuss the immigration consequences of that charge and to see if there's any way we can help that individual.
Okay, you actually mentioned a few things I want to follow up on. If someone comes to you to adjust status in whatever way, and they have a conviction in their past, um, and nothing ever happened to them, in terms of being deported, what what can be done at that point? Is there any way for them to get status? Is there any way for them to fix what has already been done in the past in terms of the criminal conviction?
Okay, so the first analysis is whether or not they have a conviction. So they might have a charge for which it was null pros, they were found not guilty, they had pled not guilty, whatever. So the first question is whether or not they have a conviction. If they pled guilty and it was dismissed, they still have a conviction for immigration purposes. Okay, so that's the first thing. And then the next question is, how serious is it? Is it a crime involving moral turpitude? Is it an aggravated felony? Where are they in their immigration timeline? Are they about to adjust status? Are they not? And then in some situations, I'll work with a criminal defense lawyer to see whether or not there's the opportunity for post-conviction relief. Can you go back into court and somehow undo the conviction? Like a writ of coram nobis. You probably know more about that than I do, but so we look at those options. Does that answer your question?
It answers part of the question, yes.
Okay.
But the other question is, if somebody is in the process of, or even if they are in the process of trying to adjust status, or if they're not, if they are not a citizen and they are charged with a crime,
Mhm.
my first question is, what can be done about that, and really, what is the first thing that person should do, like when they are charged?
Okay. So well, what they should do if they're charged is ideally they should call a criminal defense attorney, and some criminal defense attorneys already know the immigration consequences, and some don't. Please give me a call. I'm happy to discuss that with Virginia lawyers. So that's what they should do. It really depends on what stage they're in. Do they already have an established relationship with an immigration lawyer? They can call me and we'll discuss it. So are you contemplating a situation? Do you have a situation in mind that you're thinking of?
Well, I was just thinking, somebody that is not a United States citizen, not a full citizen, if they get charged with a crime and they have never spoken to an immigration lawyer about
Mhm.
adjusting status, for example, should they go to an immigration lawyer first, or should they go to a criminal defense attorney first? Should they contact both at the same time? What, in your opinion, do you think is the most important thing for them to do first?
I don't think it matters. I think you can call a criminal defense attorney. I think you can call an immigration lawyer. A competent immigration lawyer is you got to talk about that conviction right away. That
Hmm.
that individual should expect to raise it as an issue with the immigration lawyer right away. You can't wait. And then you also have to factor in the date of the next hearing. It might be appropriate for them to see a criminal defense lawyer if the hearing is coming up really soon. So, and then every criminal defense lawyer is different. They need to know enough to call it an immigration lawyer if they don't understand the consequences. of what's going to happen. They might not even be thinking about that. They're in their criminal defense world.
Mhm.
So it's ideally maybe one attorney is capable of doing both, or they get an immigration lawyer on the phone.
Okay. And then also about what you had mentioned a few minutes ago, um, you mentioned talking to a criminal defense attorney about what the case could be, pled down to or something. Can you just explain a little bit, about what that means and why that's important?
Right. Okay, so they could have a charge that subjects them to a ground of inadmissibility or a ground of deportation.
Mhm.
But if the conviction can be pled down to a lesser offense that does not subject them to a ground of inadmissibility or deportation, then we want to do that. So the government's going to reserve the right for immigration purposes to look at the reasons why it was pled down. Was it just for immigration purposes, or was it for other reasons? So that's going to be important too.
Okay, so when you say that, are you talking about the court record having some sort of indication as to why a charge was reduced or dismissed?
Yes. Yeah.
Okay.
So, and then there's strategies on the part of the immigration lawyer to keep that out of the hands of the government, and whether or not they are entitled to, the immigration is entitled to a copy of that is a legal analysis. Sometimes it can differ by state.
Okay. So if somebody does have a charge that is reduced or dropped, or they end up not being convicted of the charge that's going to pose a problem, let's say the charge they're convicted of is fine for immigration, or it's totally dropped. Can the immigration court, or in the course of trying to adjust status, can the government ever try to go back and look at the original charge, or is the fact that it is dismissed or reduced satisfy the requirements so they won't be in trouble, basically?
In my experience, they just look at the what's called a criminal disposition or a final disposition, and in Virginia, it's that warrant. It's the backside of that warrant that typically says how the person pled and what the disposition was, and if they were found guilty, what the penalty was. That's really what the government is going to look at.
Okay. So in looking at that conviction, you had mentioned aggravated felonies, you had mentioned crimes involving moral turpitude. Um, is there one that's worse than the other one? Does the amount of jail time make a difference? Does any jail time make it worse?
Oh, for sure. Yeah. An aggravated felony for which the sentence was a year or more. Excuse me, a charge that's going to be interpreted as an aggravated felony, added with it a year sentence. That's going to trigger the aggravated felony provision under the Immigration and Nationality Act, and it's going to subject them to a ground of deportation for sure. So aggravated felonies are really of concern. However, crime involving moral turpitude in many instances does make you inadmissible or potentially subject to deportation. So if I could talk about that for a minute, crime involving moral turpitude can make you inadmissible unless the potential sentence was less than a year and you got less than 6 months, or you were under the age of 18 at the time and it was more than 5 years before a visa application. So there is a little out there that could potentially have. We look at whether it's a class 1 misdemeanor, which is that year sentence. So that's something I look at. I just know, I happen to know offhand that a class 1 misdemeanor in Virginia has a potential sentence of a year, so I can go right to that as well. And one other thing I want to mention about crimes involving moral turpitude is if a person has a drug charge, any drug charge, marijuana, cocaine, whatever it is, any drug conviction, that is a ground of inadmissibility. They're inadmissible. There's a waiver available if it was marijuana and less than 30 grams. But clients, they'll gloss over that. They'll be like, yeah, there was a marijuana charge. You have to zero in on that, and I have to get the documentation that shows the quantity. And most times it's really a very small amount. but I have to have that documentation. So that's one thing. And then I want, you're trying to jump in, but I also want to mention crimes involving moral turpitude in a deportation context as well.
Okay. I wanted to address the drug actually while you brought that up. If a state eventually changes drug laws, something is, decriminalized, or the amount is not, later down the line, the amount of possession changes and it's not a felony anymore, it's a misdemeanor, something like that. Will that help, or does the immigration court look at what the law was at the time the person was charged with that offense?
At the time they were charged with the offense.
Okay.
Yeah, because it's how that law applies to in the Immigration and Nationality Act, and it's any conviction for any drug charge.
Okay.
Yeah.
Okay.
Yeah.
Okay. So I didn't want to interrupt. I just wanted to ask when I thought about it. You wanted to mention crimes of moral.
Sure, yeah. Interject, any time. But about the crimes involving moral turpitude in a deportation context, it's if you have crime involving moral turpitude for which the potential sentence under the statute of conviction is 1 year or more, and it occurred within 5 years of a lawful admission, you are subject to a ground of deportation. Lawful admission is the date that you got the green card. Okay, so if 4 years into your green card, you commit a class 1 misdemeanor, and that class 1 misdemeanor is also a CMT, you are subject to a ground of deportation. Now, yep.
I was just, when you say subject to a ground of deportation, what does that mean?
Okay, so that's very important. Just because you're subject to a ground of deportation doesn't mean you're going to be deported. Mm-hmm. Okay, so ICE, Immigration and Customs Enforcement, would have to have an interest in lodging what's called a notice to appear against you to go in front of an immigration judge to face the possibility of deportation. So that's one issue. And then the other issue is if they don't do that, then how's it going to matter in an immigration context? It's going to matter when that person goes to apply for their next immigration benefit. So for most people, it's either a green card or it's naturalization.
Mm-hmm.
So that's when it's going to come up.
Okay. And you had also mentioned, I don't want to get you off track from where you were going, but you mentioned something about 5 years, waiting 5 years after the offense. Can you explain exactly what you were talking about? I think you mentioned in the context of a juvenile offense.
Oh, okay. So that has to do with a CMT and with in an inadmissibility context.
Oh, I'm sorry. Okay, but could you describe that a little bit,
yep.
just to be clear?
So you have a conviction for a crime involving moral turpitude, and that is a ground of inadmissibility unless there's some exceptions. Mm-hmm. If you were under age 18 at the time that it happened and it was within 5 years of a visa application, or the potential sentence under state statute was no more than a year and your actual sentence was no more than 6 months in jail, and that includes suspended sentences. So that's called the petty crime exception. So yes, you've triggered a ground of inadmissibility, but there's an exception to it, so you're not technically subject to that ground of inadmissibility.
Okay. So how exactly does the 5 years make a difference? The person has to wait 5 years after that conviction, or they only look back 5 years?
Okay, so it's 5 years before a visa application. So that has to do with your ground of inadmissibility, and they had to have been under 18. So okay. I don't get too many of those. But in a deportation context, if you've committed a crime involving moral turpitude for which the potential sentence under state statute was a year or more, and it was within 5 years of a lawful admission, then you're subject to this ground of deportation. 5 years of a lawful. So let's say you got your green card January 1st, 2015, and you commit a crime July 2018. 3.5 years later, you're within 5 years from your last what's considered a lawful admission. That date on your green card, that's considered your admission.
Mm-hmm. Okay, so then if you're convicted of that offense within the 3.5 years, then what happens? What's the result of that?
You've triggered that ground of deportation.
But is that where that petty offense exception comes?
No, that's the ground of inadmissibility.
Okay.
That petty offense, it applies to one crime.
I'm even having trouble keeping it straight.
Yeah, that's okay. It applies to one crime, and it applies in an inadmissibility context. But this deportation context, I mean, now you've got a lot of ins and outs that arise there. And I don't do too many removal cases, but there's You'd have to talk to someone who does the removal if they have any form of relief once they've triggered a criminal ground of 237H, something like that, and whether or not that applies in it. And then you're in court, and then it gets a little bit more complicated. What can happen if you trigger a ground of deportation, you apply for naturalization, what they could deny you, and they may or may not refer you to ICE. They issued a memo recently about the circumstances under which they'll refer you to ICE. So that's a whole other thing too. So we try and catch it. So if a client comes to me and I know they're going to trigger a ground of deportation, it's up to me as a practitioner to stop the process.
Mm-hmm.
And I would have them not move forward with a naturalization application if I know they're subject to a ground of deportation.
Okay. Okay. You had mentioned inadmissibility and deportation. Can you just explain a little bit who is affected by each of those different results? You know, what a status would be, what somebody's status in the United States is that makes them inadmissible versus making them deportable.
Right. Okay. So when you're applying for a green card, you're knocking on the U.S. government's door and you're saying, will you let me in? And the U.S. government answers and says, maybe. Okay. So did you commit certain crimes? Do you have certain communicable diseases? Are you likely to become a public charge? Have you ever smuggled anyone into the U.S.? You know, all a long list of potential things that could make somebody inadmissible to getting a green card. Okay.
Mm-hmm.
Now, if you are someone who already has a green card and you're applying to become a U.S. citizen, you're applying to become a naturalized U.S. citizen, you are potentially subject to a ground of deportation. After you have your green card, you could still get deported. Before you have a green card, you could get deported. They would call it excludable. It's now called removal, by the way. Then after you have the green card, you wouldn't be called inadmissible or excludable. You would be called, it would be more firmly, you would think of it as deportable.
Okay. So when you talk about crimes, convictions that make someone deportable, and you had mentioned the aggravated felony and things like that, that's for somebody that has a green card that already has status in the United States.
Yes, yeah, they could be subject to deportation. Now, if they have no status and they committed an aggravated felony, it's going to be up to ICE to find them and go after them.
Okay. Okay. I did want to ask you a question about a specific crime, because you mentioned aggravated felonies, you mentioned crimes of moral turpitude, you mentioned drug charges, and those are pretty clear. But one question that I had was, how do DUI charges, at least in Virginia, to the extent you can answer, how do DUIs affect either inadmissibility or deportability? Because just from my reading of it, it doesn't look like a DUI conviction fits clearly into any category that would pose a problem.
Okay, so a single DUI is probably not going to be a problem. Okay, so we have the issue of, we talked about inadmissibility and deportation, but when you're applying to become a U.S. citizen, you also have to look at good moral character. Do you have any bad acts within the past 5 years, such as a charge for which you were not convicted? Okay, or an arrest that didn't rise to the level of a conviction. Those are things that we want to look at. So a DUI generally is a single DUI. Now, 2 DUIs, and you're probably going to be found to be someone who is lacking in good moral character. Okay, so we do, especially if it was within the past 5 years. They can go beyond 5 years if they want to. That's the look back period from the time you file the naturalization application backward 5 years. They're going to really examine that period of time. They can go back even further if they want to. So if you have 2, that's a problem. And in fact, I think they just issued a memo to that effect about having 2 DUIs being problematic. If you have a DUI where you were driving on a suspended license or a revoked license, that could potentially rise to the level of a CMT.
When you say could potentially, this is the way a lawyer asks the question. What exactly does that mean? How could it potentially rise to the level of a CIMT, crime of moral turpitude, and why?
Well, because if you commit a DUI when you knew or should have known that you weren't allowed to drive to begin with,
Hmm.
right? You had a suspended license, you had a revoked license. In the eyes of immigration, that could change the way they view it. You know, and I guess you could say, well, the person knowingly got behind the wheel, so why isn't every DUI a CMT? But that's just to the best of my knowledge. That's my recent knowledge, that if you did it while you also had it suspended or revoked, they're going to look at that.
Okay, so it sounds like from what you're saying, when the person gets to immigration court and is um, in the process of potentially being excluded or deported, immigration court looks at the actual crime, the actual conviction, and could potentially infer um, a knowing and willful violation of law that you had mentioned earlier. Am I understanding that correctly? They could infer that based on the just the crime that was committed.
Well, in a DUI context, yes. Now, CMTs in general, they'll look at the language in the statute, and they'll determine whether or not it's a CMT, and it's up to the practitioner to fight that. If it's divisible, and under what section of the statute was the person charged. So statute, as you and I know, statutes are divisible.
Hmm.
So it's going to depend on that individual's situation.
Okay. You also mentioned good moral character and arrests that didn't result in convictions. I was
Yes.
wondering if you could explain that a little bit, because earlier we talked about trying to get a certain charge down, either dismissed
Mhm.
or reduced,
Mhm.
so that that charge wouldn't be a problem. But it sounds like even if you did that, the fact
Yes.
that the person was still charged or arrested could go against them in determining good moral character. Is that correct?
Yes, yes, I'm so glad you brought that up. And as a corollary to that, if you get it expunged, that has no impact for immigration purposes. They're
Really?
still going to look at that conviction even if you get it expunged. So don't think that's going to help you in an immigration context, because it's not. So when you apply to become a naturalized U.S. citizen, they look at your behavior for the past 5 years. They look at bad acts. Um, if you committed a bad act, you're going to be given an opportunity to offer evidence of extenuating circumstances. I do a statement of extenuating circumstances for the client. Last time I did the research on this, I couldn't find out what exactly does extenuating circumstances mean. The last time I researched it, and I couldn't find a definition anywhere. And the way the client interprets extenuating circumstances is their side of the story.
Hmm.
Their side. And then I have to make a judgment call whether or not it really is extenuating circumstances. Was there a misunderstanding? Was there really two sides of the story? Was there an innocent motivation behind the actions that led up to the conviction? And then I look at it through the eyes of an adjudicator, and I put our best foot forward, and I call it extenuating circumstances. And I have the client acknowledge the mistake and promise not to do it again, and things like that.
Okay. You had also mentioned, as I just alluded to, trying to get a charge down. If the person's deportable and it's an aggravated felony, for example, or whatever that person's situation is. Um, and then I suppose you would tell the criminal defense attorney what it is that the person could be convicted of based on their individual situation, and what they can't for immigration purposes, right? So what if there is a situation where it is just not realistic or possible in the defense attorney's perspective that a charge can be reduced to something that you would advise is okay for immigration? It's just not possible. So a situation would be, they try, but it's just not going to work out. So they either have to, risk going to trial on something that is a serious offense, and they don't think that they have a good case, right? They have an offer for something that is a good offer, but it's not it still doesn't comply with what would be okay for immigration. Do you understand what I'm saying? What would you advise in that situation where the result that you as the immigration attorney would be looking for is just not realistic or possible?
Okay, so if I understand you correctly, this person is in a lose-lose situation. If
Yeah.
they, yeah, if they, okay, if you lessen the charge, they're still subject to a ground of inadmissibility or deportation, even if you're able to lessen the charge,
Hmm.
assuming you're able to lessen the charge, or they go to trial where they're gambling everything, and if they're convicted, they would also be in a situation leading to inadmissibility or deportation if they have the conviction. And on top of that, you think they're likely to be convicted.
Right.
Um, yeah, that person is in a really bad situation. What I would do in a situation like that is I would assume the conviction and I would prepare for what their immigration uh, world is going to look like post conviction. So, for example, if I know they're going to get a conviction and it's going to be a real bad one, like an aggravated felony or something subjecting them to deportation, something else subjecting them to deportation,
Hmm.
I would say, if you are deported, this is how we can get you back in to the United States.
Is there anything at that point that can be done to try to prevent them from being deported once they have that conviction?
Not that I can think of.
Okay.
It's going to be up to ICE whether or not they want to go to their house and get them or wait for them outside the courtroom or whatever ICE does. Um, but once they have it, I mean, unless there's a possibility for some kind of post conviction relief to undo the case. I don't know if you're familiar with matter of Padilla. That was really that was the last one. You know, if we can. If I can work with the criminal defense attorney, we can do a writ of coram nobis somehow to undo it. In some there's a statute of limitations on that. In some states, it's easier to do that than others.
Hmm.
We'll see if there's a possibility for that. That's the only thing I can think of.
Okay. But once a person, let's say a person is convicted and sentenced to jail time or whatever the result is, and then ICE does pick them up, how do they have a chance of even fighting their case in immigration court? Because that's really more your wheelhouse than mine. Once the conviction happened, what?
Okay, all right. So yeah, that's a great question. So once they're in, and I don't do a lot of removals, so you have to bear with me about this.
Mhm.
Once they're in removal court, they could be eligible for a form of relief.
Mhm.
So the conviction may have barred them from eligibility for a form of relief, though. So
Okay.
that's something to keep in mind. But traditionally, in immigration court, you can apply for asylum or you can apply for what's called cancellation of removal. There's one type of cancellation of removal if you have a green card. There's a different type of cancellation of removal if you don't even have a green card. You have no status at all. So yes, it will be up to the attorney to make an assessment of their chances of relief in immigration court. But I always go to if they're deported, how can we get you back in? Are you subject to any time limitations before you can apply for permission to get back in? Do you have a petitioner who can petition? You really have to start the process all over again. So that's what I go to if I think someone's going to be deported.
Okay. Well, we touched on a lot of different areas there. I think we're definitely going
Yeah,
to have to do some follow up webinars because there's just so much to talk about.
sure.
But is there anything else, first in the context of criminal convictions? Is there anything else that you think the viewers should know or that I haven't asked?
Well, the two big ones that I had wanted to say is that and I had already mentioned, is that any drug conviction is a ground of inadmissibility. And also, not only are you dealing with inadmissibility and deportation, but you're also dealing with good moral character. So those are some things that I wanted to mention or emphasize, I should say.
Okay. Um, and then just back to what it is that you that you do on a daily basis. Is there anything else that you wanted to talk about in terms of adjusting status or helping families?
Is there anything I wanted to talk about adjusting status?
Right. And anything else aside from the criminal side of it that you do that you think viewers should keep in mind? Aside, like not looking at criminal convictions, just in general when they're trying to adjust status or talking to an immigration lawyer.
Sure. Please retain all your paperwork and bring a copy of that with you to my office. If you wind up doing anything on your own, applying for an immigration benefit on your own, please retain which I don't recommend, but people do, and sometimes they do it with success, so I don't want to rule that out. Please retain a copy of everything. So in case there's any problems later on and you do wind up needing a lawyer, we'll know what was filed. I mean, we can also do a FOIA request to get that, but it'd be a lot faster if you already have a copy of that paperwork with you. So don't try and stay out of trouble. And bad things happen to good people. I tell my clients that all the time. I had a client once who had a weird conviction. He had smuggled a camera into Australia, I think it was, and it was an illegal camera. I mean, he had no idea what he was doing. So what my point is, bad things happen to good people. And don't vote, please. Whatever you do, if you're not a U.S. citizen, you cannot vote. Do not claim to be a U.S. citizen on any paperwork anywhere. Of course, the I-9 comes to mind, which is an application to show that you have authorization to work in the United States when you apply for a job. We all know the I-9, column A or column B and C. You either produce a passport or you produce, and I'm simplifying this, or you produce your driver's license together with your Social Security card. Please don't even accidentally claim to be a U.S. citizen. A mortgage application, an employment, a different type of employment application, an insurance application. If someone else fills it out for you, check behind them. People get deported for these reasons. Is it fair? Maybe not. You know, it depends on your perspective. Don't vote. Don't claim to be a U.S. citizen. Pay your taxes. Pay your alimony. If you have a plan, if you have a plan, if you have a payment plan with the IRS, get documentary proof of that. If you alimony, documentary proof of that. If you're married, you don't file head of household. That's against IRS rules. Things like that. Keep a good, clean record. Establish a relationship with an immigration lawyer early so we can help you and walk you through the process and help you troubleshoot. If you're fighting with a loved one and you need the green card, let us know. There may be a conflict of interest. I might have to withdraw if I was representing the both of you and refer one of you out to someone else. But if she throws you out or he throws you out, all isn't lost. Talk to us.
Okay. Well, thank you very much for all of that. But Amy, I actually wanted to ask you a couple of questions because it looks like I just noticed some questions in the comments. Lisa asked, is any felony grounds for deportation?
Probably. If it's considered a felony on the state level, we'd have to read it. If it's a felony on the state level, I'm going to take a guess. It's probably a crime involving moral turpitude. I don't know whether or not it would be an aggravated felony for immigration purposes. It may or may not be. But if it's a felony on the state level, it's probably a crime involving moral turpitude. So go see your immigration lawyer right away.
Okay, well, that's good to know. And then another question: what if the person is currently incarcerated? Will ICE pick them up if they are a green card holder? For example, they're serving 5 years.
Okay. So there's another ground of inadmissibility is if you have 2 or more offenses and it totals 5 years incarceration. They can. It's up to ICE. It's up to ICE, and that's where your secured communities comes in, and all this conversation surrounding the conversation between local law enforcement and ICE, and whether or not there's a detainer and the communication between those 2 agencies to go pick them up. So, and that's differing in a state by state basis. And again, ICE would have to have a reason to go get them. They'd have to know the person was undocumented. You know, they don't know the person is undocumented. They might suspect it. So,
well, I think there are some jails in Virginia, at least, that have, you know, immigration can come into the jail and interview people and basically find out what their status is. Do you know anything about that? I mean, what's your experience seeing that? Do a lot of jails do that?
Yeah, well, I don't know if they're allowed to do something like that.
Okay.
Okay, so you might want to mention this to an organization like Care Coalition or something like that, because I don't know if they can go in there and start inquiring about somebody's immigration status.
Okay. And then I'm not sure based on the question if the person meant serving 5 years on a felony or a total of 5 years. Does that matter? So the question is, what if they're currently incarcerated? Will ICE pick them up if they are a green card holder? They're serving 5 years. So does it make a difference if they're doing 5 years on, more than 5 years on two misdemeanors, or if it's 5 years on a felony? Does it matter, or is the 5 years an important amount of time?
No, no, it's not. It's a ground of inadmissibility. I think it's where you have two or more offenses, and the aggregate sentences come to 5 years. The ICE agents, they're not lawyers, so once in a while they could pick somebody up for whom it's inappropriate for them to have picked up. They're actually not subject to a ground of deportation.
Mhm.
So it's really incumbent on the lawyer to get in there. The lawyer, if it's appropriate, a lawyer could file a motion to terminate the charges. So, you know,
So basically, ICE is only going to go pick somebody up, whether they're in jail or not, I guess, if they have a reason to, if they know the person is not a citizen. Is that correct?
yeah. I mean, I don't know what goes on over at ICE, but yeah, they can do that. I've heard of them hanging out in courtrooms or wherever, you know, they whatever their protocol is. What I hear about is them raiding people's houses, and that's what they're gonna at that point have a lot of evidence of convictions. They're probably gonna know what they're doing. They got someone who they have a good case against. So it's not that, of course, they're ICE lawyers, and they have a good case again. But again, the lawyer has to carefully examine the notice to appear. There's allegations and there's charges, and it has to be correct. And if it's not correct, and if the lawyer has a good faith basis, the lawyer should be brave enough to go ahead and file a motion to terminate. If the motion to terminate is granted, they can recharge if they want to. They can issue a new one if it's just a matter of correcting it. So,
Let me ask you another question. If a person if a person gets to immigration custody, are they entitled to a lawyer like they are in the criminal context if they're arrested?
no, they're not entitled to a lawyer. That's in a criminal context.
Okay. So if somebody is in immigration custody and cannot afford a lawyer, then what do they do?
They represent themselves. They concede to the charges. They accept it that they're deportable. And if they're in detention, the ICE will make arrangements to have them flown out back to their country of origin.
And how long generally, once a person gets into immigration custody, between when they first get there and when they are, adjudicated or determined that they're going to be deported, how long is that process?
Oh, it depends. So if they're detained, they're on a faster docket. So it can be a short amount of time. It can be a week or two before they're in front of the judge. The first hearing is called a master calendar hearing. Sometimes they're able to get a lawyer before the master calendar hearing, sometimes afterward. Sometimes if it depends on what stage the lawyer comes in, the lawyer might have to do a motion to continue
Hmm.
because they need to get up to speed. There are lawyers who volunteer and take deportation cases pro bono. So if a non-citizen is lucky, they can maybe get a lawyer to take their case pro bono.
Hmm. Hmm. But you said they're fast tracked if they're detained. So just for example, how long if somebody was and detained, meaning in jail before immigration picks them up, and then continuously in jail during the immigration process? Generally, how long would that
Mhm.
be? Or
Okay, so that's
how quick could it be, I should say?
okay. So that's one type of detention, that they go from jail to immigration detention. Some people are just in immigration detention.
Hmm.
But once they're detained, I mean, it depends on the judge's docket. I can tell you, I've personally seen a fairly quick turnaround. Within a week, they could be in front of a judge.
And then determined to be deported?
Well, they have a master calendar hearing, so it depends what goes on there. The judge is like I said, I don't do much removal work. The judge is probably going to say, do you have a lawyer? No, I don't have a lawyer. There's an interpreter there, by the way.
Mm-hmm.
And, I'm planning on getting one. No, I don't have one, whatever. Then they go through you prepared to go through the allegations and charges? Yes, no.
Mm-hmm.
Is it true that you're a citizen of this country? Is it true you entered on this date? Is it true, you have allegations and you have charges? And if the notice to appear is defective, then it seems to me I don't know what goes on, but it would seem to me it would be incumbent upon the lawyer to do a motion to terminate. Now, if it's defective and the judge catches it that it's defective, I don't know what happens. If there's no defense counsel, then it seems the government attorney could say, "Let me fix it."
Mm-hmm.
They could just go and fix it. So,
okay. So that master calendar hearing is like an arraignment where they tell the person
sure.
what. Okay.
Sure. And then if it could go to a bond hearing. It could go to an individual hearing. An individual hearing is like your trial. So,
but you had mentioned that it depends on what happens at that master calendar hearing where the case goes. So is the case
Mhm.
ever done at that master hearing?
I don't know. I mean, if they don't have a lawyer and they're not going to get a lawyer and they concede to the charges, I imagine that the judge is going to want to dispose of the case, and I guess the judge, he or she, could do a final order of removal right then and there. So, but if they speak up and they say the individual says, I want to defend myself, or those charges are wrong, or I'm planning on getting a lawyer, then maybe the case will be continued to another hearing. Or I'd like to ask for bonds. They can go into that right then and there.
Okay. And then let's say the case is continued after that master hearing for a bond or for adjudication or a trial. Generally, how long after that would that whole process take? If they're not found to be, if they're not ordered deported at that hearing, then how much longer might it take for them to have a chance to try to find a lawyer and help their case?
Well, the judge could ask the defendant, the respondent is what the person's referred to. How much time do you need? Can we do this in, can we, is a week okay? Can we do this in 2 weeks, or whatever it might be? If
Mm-hmm.
they, like I said, if they're detained, it's going to move faster.
Mm-hmm. Okay. And assuming somebody does not have an attorney throughout that process and in the immigration court, and they do get deported,
Mm-hmm.
Is there anything they can do after that? Or the fact that they were deported is going to prevent them from ever coming back or trying to adjust?
No, that's where I come in. If a person has a final order of removal, we look at how we can get the person back in. Are they subject to any bars? And sometimes you're not. Just because you're deported doesn't mean you're subject to a bar. And there's different types of bar. There's 5-year bars, there's 10-year bars, there's a 20-year bar. So we look and see whether or not a bar is applicable. And if there is there a waiver, or is there not a waiver? So one of the 10-year bars has no waiver available. You have to stay outside the United States for 10 years. There's another 10-year bar that does have a waiver applicable. So people get confused about that, but there is one where you have to stay out and one where you don't, if you're eligible for the waiver.
Okay. Wow,
So,
this was a lot of information. We talked for almost an hour. Yeah. Well, I'd definitely like to do this again, Amy, because I think there are a lot of more specific issues we could address. And then also based on the questions, I think I'll also ask anybody that's either watching this live or watching the replay to write a question in the comments. And then that will help Amy and I figure out, what we want to address the next time too. And then also, if you have a specific question for Amy or know somebody who does, we're going to put her contact information in the comments as well. So I guess on that note, if there's anything else you want to say, Amy, before we leave.
Well, these are general comments. I hope they're helpful to you. Every case is on a case-by-case basis. What kind of immigration benefit you're eligible for. There's deferred action for childhood arrivals. There's people who are eligible for a U visa if you were the victim of a crime, and there's of course there's asylum, there's withholding of removal. Not everyone is eligible for a family-based category. They don't have the relationship, but it's really on a case-by-case basis, and then what goes on in immigration court also. Yeah, I mean, my website is immigrationfallriver.com. Please come visit me. And yeah, reach out to Jean. If you have a criminal conviction or a criminal charge, she's an expert, and then she's happy to call me. We'll see if we can work together to help that individual.
Mm-hmm. Oh, and Amy, that actually leads me to one of the final questions I wanted to ask you. Can you still represent people down here in Virginia, even though you are in Massachusetts currently?
Absolutely. As of today, I'm still licensed in Virginia, and I travel back to Virginia periodically. Like 90% of my clients are in Virginia, and they are still hiring me from Virginia, even though I've moved away, because I had a practice there for so long. So please don't hesitate to call me. I was in Virginia for a long time. It's not a big deal for me to go back there if I have to. I really don't have to, because we can do anything virtually. I communicate with clients by text, by WhatsApp, by FaceTime and Duo, a Facebook video. And the traditional ways we communicate is phone and email. And then once in a while, a client will send me a fax, or they'll scan in a document and send it to me as an email attachment. Really, we work virtually with no issues whatsoever.
Okay. All right, great. Well, thanks, Amy, so much for taking the time to answer these questions. I hope this was helpful for everybody watching. And like I said, feel free to leave comments. If you want to like and share this video, it will be up on Humbrecht Law's Facebook page and on my website, humbrechtlaw.com. It will be on Amy Long's social media. So it will still be available after this live broadcast. But if you know anybody that you think should see this video, please feel free to share it with them as well. So thanks everybody for tuning in, and we will let you guys know when we have another one scheduled, which we're probably going to end up doing. So everybody have a good day and stay safe and have a good weekend.
Yeah, Jean, anytime. Thank you.
All right. Bye, guys.
Take care.